Do the ERISA disability insurance regulations really work and provide a full and fair opportunity for a review of an improperly denied or terminated benefits? Hey, I'm nationwide disability attorney Nancy Cavey, and I will tell you that the current ERISA regulations are really an improvement over the old regulations, but disability carriers often will hide the ball and, in my view, fail to clearly explain why they denied or terminated benefits. Look, we know they don't want to pay. They know that we know that they don't want to pay. And they will use these regulations to muddy the waters, hoping that you'll just give up and go away. I'm going to be explaining in a number of videos the games that are being played by disability carriers and plans with these regulations and what you need to do to make sure you really do get a full and fair review of your claim. Now, today, I am going to talk about one of the primary violations, if you will, that ERISA plans or disability carriers engage in, the mistakes that they make to justify this denial or termination of benefits. Now, you may have been stunned to get this denial or termination letter. You've read it from cover to cover, and you don't necessarily understand it. If you don't, it's time for you to contact an experienced ERISA disability attorney. But let's talk about the denial letter. The denial letter will recite in confusing terms and in accurate terms the basic plan terms or policy terms that are the basis of the denial. I never ever really believe that what's being cited in the policy or plan language as being correct in that denial or termination letter is in fact really correct. Let me give you an example. One of the most important terms in a disability policy or plan is the definition of occupation. You have insured not your job, but your occupation. Now, there are varying definitions of occupation, and many disability carriers have different policies or plans with different definitions. And sometimes they'll quote the wrong one, or they'll only quote part of it. So let's say the definition is an inability to do the material and substantial duties of your occupation. But occupation is defined by the terms of the policy as your occupation is performed for your employer. Many disability policies will define occupation as it's performed in the national economy, not as it's performed for your employer. So many times I'll see a denial letter where they're actually misquoting the applicable policy language, in this case, the definition of occupation. Right off the bat, we always want to get a copy of what's called the summary plan description, which is a summary of the language, but we actually want to see the policy or plan that's applicable. We want to check the language that's in the governing policy or plan documents and compare them against the standard that they are citing in the denial or termination letter, because that's an avenue of attack. You can see that that's just one of the games that disability carriers or plans will play in preventing you the opportunity to have a full and fair review of your denied or terminated claim. Call us today at 727-894-3188 for a complimentary consultation.